Hey, what's up, guys? Welcome. Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And I don't even know. The internet is a wondrous place. It is a wondrous, wonderful wonderland where all of the exceptional people can exist in one fine place, and where I don't know, just everything great can happen, and I always forget to do this. My automatic backup just really hates streaming. There we go. Got rid of that problem. All right, so you can find anything and everything and every type of person on the internet. And I don't know why, but I seem to collect just a healthy amount of them following me around. No, it isn't. He's dead, Cormoran. Carlton's dad, Uncle Phil, he's dead. Yes, Dice David, you do. You do. Just kidding, buddy. But I would appreciate it. It'd be wonderful. But feel no obligation. All gifts are appreciated. None are expected. So, today, and I'm gonna give it a minute. I announced this late because I was very busy all day today, and therefore I didn't have a subject picked out specifically earlier in the day. And so my producer was asking me like what thumbnail should happen and all that stuff, and everything happened late. So everything is late. So I'm gonna do an internet live stall tactic and just talk about something for a little bit and let people jump in and let the watching fill up a bit before we get started. You know, kicking into reading through these things. But I'm testing out this new sort of format. It's not a new format for the show, but it's a show I would like to do on occasion where basically we go through and hit a couple things kind of quickly rather than digging super deep into them. Because one, they're interesting headlines that I don't always have time to read, but they're definitely legally related. And two, what's in those articles might be interesting material for a full show, or it might not. And this kind of lets us hit a couple subjects, and then if there's something really interesting, we can maybe dive deeper into it, either on the same show or have a later show or something like that. So here we go. We've got, so tonight, you know, getting back into this, my brain is just fried. And it's not because today was particularly trying or challenging. It's because I get to deal with challenging people. And sometimes they just go ahead and shut me down. Shut my brain off completely because I can't understand them. Can't understand them at all. And a lot of them are not lawyers. They're not lawyers talking about how lawyers should lawyer. Specifically me. Of course, I have to contextualize this to myself. But, you know, they're talking about things that I do wrong. And the interesting thing is a lot of times, not always. I mean, there's fair criticism of anybody, me included. I will say over and over again, you know, this is my opinion based on my experience, training, knowledge, all of that stuff. Happy to be wrong and corrected. Open to criticism. But when you have people who are wrong in their criticisms and demonstrably wrong in their criticisms, it becomes really frustrating because it's like, no, you're wrong because you don't know this field. And then they don't understand why you're telling them they're wrong. So, you know, you run into this stuff and it's mind numbing, especially when they're super stubborn, which is what the internet produces, right? Stubborn people. We're going to have some pineapple whiskey in just a second. So that's been happening. But other than that, we've got this Carlton dance that we're going to talk about with Fortnite. Everybody's suing Fortnite, by the way, not just Carlton. Also, the backpack kid, I think, is he the kid who did the floss? I think he's suing Fortnite. Suing Fortnite's apparently a meme now. And it might be because of what Fortnite is doing, right? It might be their fault and their very playful approach to game creation that is driving these lawsuits now. Because now they have a playful approach, maybe took some liberty with what's legal and not legal, or maybe didn't even think about it. And now they've got money, though, because they've got a ton of people playing their silly game. When you've got a ton of people playing your game, you've got a ton of money coming in. So now people see that and go, wait a minute, wait a minute, wait a minute. I really do care about the money that could be mine, even though, like, Carlton's not making Fortnite. However, the developer of Fortnite could have, you know, contacted Carlton and gotten a license, purchased a license to use the thing. But I don't know. So we're going to read through this article. We're going to talk about copyright of a dance. We're going to talk about some possible problems. I do have the civil complaint for this downloaded, but I haven't read through it yet. And so I don't know if I want to do the full thing. We might take a peek at it, but I don't want to do the full thing tonight. This is a little bit different. This is a deep copyright issue. So we'll talk about that. So then you've got, on the other hand, you've got a developer of a game called Escape from Tarkov, which is like a realistic, whatever that means, shooter where you're like, you have to escape from this place or something and you shoot some Russians. I don't know. Something like that. Hold on one second. Oh, this is better here than it was in Hawaii. So I sampled this in Hawaii, and it was, this is, let me show this on stream, I guess. This is Paniolo. This is a blended whiskey from Hawaii. They actually, I forget what, they import a bourbon, a bourbon, right? And then they don't really age this thing long. They get like a 3-year bourbon from a reputable distillery, but they get a 3-year bourbon, and then they blend in the pineapple whiskey, the pineapple distillate that they use. I shouldn't call it a whiskey. They blend that in with the bourbon and then dilute it down to 40% alcohol. And they claim that that gives a similar result to the aging process. And that might be true. They used to age it in bourbon barrels when they first made it. And instead of doing that, they went with the much lower cost. We're going to add distilled pineapple juice into this whiskey and blend it, and we'll get the same result. I don't know if it gets the same result, but it's good. It is very good. But when I tasted it in Hawaii, it tasted, there was too much sweetness from the pineapple. I don't know if that's a bottle to bottle inconsistency, or maybe I'm just in a different mood. The smell is good. But it may be the sweetness and the acidity carrying over to kind of help with the fake aging process. I don't know. Good. It's a good cheap bottle of whiskey. This is not an expensive liquor. It's like $45 a bottle. It's pretty good for that range, right? All right. Okay. So, Jade Kitten, no Greer tonight. Sriracha was not available tonight. However, next week, Wednesday, I think we're going to have the Greer stream. I'll announce it as soon as we have it locked down. Okay, I'll announce it as soon as that. But it's looking good for next Wednesday. And next week's going to be cool. Also, on Thursday of next week, I've got Mark Kern slated to come on. Mark Kern is one of a producer of Diablo 2. He was a team lead of the development team of World of Warcraft. We are not going to be talking like primarily about Blizzard and video game creation, which are what his normal interviews are, I guess. but we are going to be talking about business, tech, and law coming together, and we're going to be talking about these payment processors. I've been calling it the payment cartel. We're going to be talking about credit card processing. We're going to be talking about Silicon Valley, I guess, moral policing the world and going ahead and deciding that they need to instill a specific set of values into their customers and to enforce that through the merit of the use of their products. We're going to be doing that. We'll talk about that. I'm not sure how long that interview will be, but he has agreed to come on the show, and I think we'll have a great chat. So far, we talked very briefly, and things seem to be going in a good direction with it. But that'll be next Thursday. So hopefully Wednesday of next week, Greer. Thursday of next week, Mark Kern. And then, of course, we've got other stuff coming as well. Business, tech, and law, the ultimate action RPG. I'm hoping maybe he'll join me in drinking and I can get him hammered and we can make fun of like recent Diablo moves or something. Get your credit card number. Okay. So anyway, Escape from Tarkov. The developer of Escape from Tarkov recently hit a YouTuber with 47 DMCA takedown requests. And some of the reasons given are like bad-mouthing the product and stuff. So we'll talk about that very briefly. And then there are some really big, major political law stories that are out there, but they're hard to report on in depth because there's not a ton of details due to the nature of what's going on. One of those, of course, there's a story about Mueller's team getting apparently winning an appeal in a grand jury indictment, but all the documents are sealed. So that could be Trump related. It appears to be related to a Russian private company. So it seems to be involved in the collusion case or whatever. So we'll talk briefly about that. There's been a big ruling on the immigration front where a federal judge has not only said that the deportation process for asylees that was implemented under Sessions is unconstitutional. He ordered the administration to go grab people who had been deported and bring them back. So that'll be weird. I guess they're going to do that. That'll go well. And did a nationwide injunction on deporting asylees, or at least deporting them under these new credible risk rules. So that's an interesting story to briefly talk about. So we're going to talk about that. And then, was there something else? I don't know. There might be something else coming out in legal news, but those are the four big ones we're going to cover for now. And we'll see. Does Mark Kern own a phone? Carrie, I haven't talked about the Carlton case at all yet outside of this brief intro. So we're going to talk about work for hire and stuff like that. We'll see. Like I said, I do have the document, so we might skim it for their claims and see. Gift shroud, not gift should. But yeah. And yes, it is the same judge as the Flynn case. And the Flynn judge made some very interesting statements to Flynn. But he hasn't gone ahead and sentenced him yet. So that's interesting. It's all very interesting. And it's not necessarily like automatically wrong. If we're covering it, it's not because the opinion's wrong or right. Half the time I haven't made a decision yet. Okay. Let's start with this Carlton thing though. If you don't know, Carlton was a character on The Fresh Prince of Bel-Air and was a huge nerd, liked to listen to Tom Jones. So he's probably a child molester or a serial killer. I'm just kidding. Just kidding. The character, anyway. And people who listen to Tom Jones. No, although there's interesting stories about Tom Jones. Sleeping around with like prominent actresses and stuff like that. Hessian. That's a good question, isn't it? It's a good question. We'll see. We'll see. Well, I am going to talk about that when we get to that immigration case in a little bit. But for now, let's go ahead and jump into this. Oh, and let me just say, last night's stream, if you didn't see it, please go watch it. I was shocked and surprised by my interviewee. I knew he was very young, but on the interview, he doesn't come across young, comes across very impressively composed, and seems to be at least well on his way to being in the know. And I would say his global knowledge is interesting for someone his age. It's beyond what I expected. I expected a lot of cringy stuff from him, and I probably all came from me last night. So that was a great stream. It's the kid who filmed his history teacher making some strange statements about PewDiePie, and I think Keemstar covered the situation on his drama alert today and stuff like that. So lots of stuff is going on behind the scenes for that teacher. Lots of things are happening for them, which are pretty interesting. And my guest's concern was that the teacher would be disciplined or in trouble, and he doesn't actually want him to like lose his job. And there are people been making death threats and stuff like that because it's the internet. So it's produced an interesting situation. But I thought the interview was great. Very interesting guy, and I hope for all the world the best to him. But if you missed it, go check it out. The NPC teacher who takes the mainstream media as gospel. Yeah, it may be. But here's the... No, Cormoran, it's not that he slept around that's interesting. It's the stories about him sleeping around that are interesting. But anyway, buying feet pics... yeah, the NPC teacher who takes the MSM as gospel. There was a counterpoint tweeted on one of my threads that said that that clip was taken out of context from the teacher's speech. And he said that what the teacher was doing was emulating the fake news cycle by calling PewDiePie a Nazi. I'm skeptical of this counterpoint. I'm especially skeptical based on the person's Twitter bio and stuff like that. But, that is a counterpoint out there. So maybe he was just demonstrating the danger of fake news by making up a fake news story about a prominent YouTuber. I guess. I don't believe it. Mike Kelly, the state senator that told another official to kill herself, is the same person trying to use social media posts to influence gun permits. Well, that's too bad. I would hate to vote for a gun grabber just because they're funny on social media. But I hate voting for all of these people, so I guess what does it matter? Okay, anyway. Yeah, and I think the kid would say that too, based on the conversation. But let's get to this dance. Now that we're well into the show and I haven't said anything of value about the subject at hand, we can go ahead and start. Fresh Prince star Alfonso Ribeiro sues Fortnite over use of his dance his character Carlton popularized. Well, that's a mouthful, CNN. And it took two people to write this story. That's the level of quality journalism you get at CNN. You got Amir Vera and Chris Boyette. Because just one CNN journalist wouldn't do. Wouldn't do for an important story like this. But, all right. Carlton wants his dance back. Ooh. Guys, when I was in 9th grade, I think it was, our teacher taught us the impact of the 5-word sentence in a paper. You can use a 5-word sentence to emphasize or punctuate a specific point. And it's funny to see that thing pop up Carlton wants his dance back. Boom, right there in the intro. That's all we need, baby. Ugh. Ribeiro. Okay, yeah. No, Ribeiro. Ribeiro. You know what, Andrew? You can shut your mouth. Okay. Actor Alfonso Ribeiro is suing to stop 2 video game developers from selling a dance popularized by his Fresh Prince of Bel-Air character. Oh, hold on just a second. Give me a second, guys. Okay, sorry about that, guys. Had a 3-year-old have an emergency real quick. That's how life goes, though. So I apologize. I don't like to step away from the camera, but Lady Rackets and I, you may have noticed that I have a cough. Lady Rackets and I have this persistent cough, and so she is actually hopefully sleeping. And then, so the 3-year-old came to me. Anyway, let's see. Where were we? Oh, there are 2 chats that came in. Yeah, by the way, of course, I never mention this. I always mention this eventually. I forget at the beginning of the show. 2 easy ways to interact. Justice Chat is a link in the description that gives money to me and not to YouTube. So I like that. It also paints your comment right over my face, and you get a higher character count there than you do with Super Chat. And if you do that, of course, I will read it on stream. Same thing with Super Chats, although YouTube gets a bigger cut. They get a cut, which is annoying in and of itself. They also get a bigger amount of it. So either way is a great way to interact with me. All of them are appreciated, and all will be read on stream. Mithran Emrys says they need 2. One to be the anonymous source, and the other to write the crappy article. Yeah, good job, CNN. That's how you go. And then Evelyn Meza, thank you very much for your donation. There's no message attached to that, but I really appreciate it. Oh, there it is. There it is. It says, watching your show helped me pass my first legal translation course. Thank you so much. Oh, you're welcome. Glad to be of service and assistance. I appreciate you watching. Thank you so much. What's the deal with the knife in the background? I guess I could talk about that. I just picked this up in Hawaii. This is a 17-inch bayonet. I've gotten conflicting reports on where it is. The guy who sold it to me suggested it was an Enfield bayonet from World War I. And then a trusted weapons fanatic that I know suggested this is a Spanish Mauser bayonet, but here it is. This thing is, 100 years old, over 100 years old. It's in good shape. Cool thing. Found it at the leather scabbard here this is leather, and it's the original, and it's in really good shape as well. I found it at a kind of an antique and collectible store in Hawaii. I liked it, so I bought it. That's the story. That's the story. So there you go. That's the deal with the knife in the background. How much did I pay for it? It was $150, I think. I don't know if I got ham boned or not. I'm not a not a weapons guy. I like weapons, but I'm not an expert or collector or anything like that. But seemed like what you would pay for a bayonet. It was fair for me, so I bought it. But yeah, so cool find. That's the knife in the background. Let's could make a great movie. Why would Hawaii have a bayonet? Well, I think it was the guy in Hawaii. Actually, the guy who sold it brought it from the mainland. Okay. Anyone know the legal term for a lawyer deserting his post? Yeah, it's called not paying the retainer. Let's get back to this story. All right. In 2 lawsuits filed Monday, Ribeiro said the companies have unfairly profited from using his likeness and from exploiting his protected creative expression. The suits name Fortnite developer Epic Games Incorporated, Epic Games Incorporated, and Take-Two Interactive Software Incorporated, creator of the NBA 2K series and several of its subsidiaries. Epic Games declined to comment on the lawsuit. Take-Two subsidiary 2K Games did not respond to a request for comment. They could have just said neither developer responded. Or I guess they're being clear here. Epic Games declined to comment. So they did respond, said, get bent, right? We don't want to talk to you. Tillip says, the bayonet? You mean my child discipliner? Oh, goodness. That's terrible, sir. Terrible. The lawsuits ask a California federal court to bar the game developers from using, selling, or displaying the dance. The suits state that Ribeiro is in the process of copywriting the dance. Uh-oh. That's interesting. That may be a problem for him procedurally. I'll have to ask my buddy, but there are certain damages. Okay, you have to register a copyright to get certain damages from the statute under a copyright claim. So if he's in the process of copywriting the dance and he's already filed the lawsuit, but he doesn't have the copyright, he may be procedurally screwing himself over and his ability to actually recover on some of the statutory damages. But I'm not positive on that. If we look further into this, I just need to do an IP stream again with Stephen Birch, who I like to talk to on any of this copyright stuff because he does it far more than I do, which I do at, basically zero outside of just discussing it. He actually practices in the field. And so he tends to know answers like this. I can look it up, but I like to talk to him. So it's more fun. But if he's in the process of copywriting the dance, that may procedurally mess with him. We'll have to see. Ribeiro, best known as Carlton Banks from the 1990s Fresh Prince sitcom, says in the court filings that he is inextricably linked to the dance. And that may be true. A joyous, arm-swinging boogie often performed at Tom Jones's It's Not Unusual. The lawsuits say Ribeiro first performed the dance during the show's 1991 Christmas episode, which I watched. 27 years later, oh God, the dance remains distinctive, immediately recognizable, and inextricably linked to Ribeiro's identity, celebrity, and likeness, the lawsuits say. Ribeiro also performed his signature move during his 2014 run on Dancing with the Stars. He is currently the host of America's Funniest Home Videos. According to the suit, Ribeiro says Epic is faking endorsements. He's asking the court for damages that both companies stop profiting from this dance, or from the dance. The games are among the most popular video games in the world. Epic recently announced that 78.3 million users logged in to play Fortnite in August. NBA 2K series is critically acclaimed as one of the best sports games on the internet. Fortnite calls it the fresh. That's a problem. Fortnite Battle Royale is a game that pits up to 100 players against each other in a frenzied fight for survival. The last one standing wins. And if you don't know anything about Fortnite and you want to see someone who struggles to play it, you can go watch Maddox play it on Twitch. And specifically, you can watch certain people end Maddox's Fortnite chances on Twitch, which is also funny. The game provides in-game purchases like dances called emotes, which have become so popular that teens all over the world post videos of themselves doing the dances with the hashtag Fortnite dance or hashtag Fortnite videos, according to the lawsuit against Epic. The game sells what Ribeiro claims is his dance under the emote name Fresh. Epic intentionally induces others to perform these dances and mark them with those hashtags, which give attribution to and endorse Fortnite the game. The lawsuit states, and that's maybe strong that they induce them to do that, but okay. Epic has consistently sought to exploit African-American talent, in particular in Fortnite, by copying their dances and movements and sell them through emotes. Grammar issues. Similarly, the lawsuit against Take-Two Interactive says the basketball game NBA 2K sold the game many refer to as the Carlton Dance as an in-game purchase. It was sold under the name So Fresh. Ribeiro is not the first celebrity with a signature dance to sue the makers of the popular Fortnite game. Attorney David L. Hecht says he and his firm are also representing rapper 2 Milli and Russell Horning, also known as the Backpack Kid, in lawsuits against Epic Games over Fortnite's use of their signature dances within the game. Horning created a dance called The Floss in 2016, while 2 Milli created the Milli Rock around 2015. More plaintiffs are coming out of the woodwork each day. And that is true. That's true. I didn't miss a super chat. How dare you? How dare you? There is one there, but I haven't gotten to it yet. Siren Jag says, could you please wield that Zayd sticker again? I just pulled up the music from the scene where Kirk and Spock fight with those big Q-tips in Star Trek in another window. Yeah, here it is. Although calling it a Zayd sticker is rude. But yeah, unfortunately, I don't know if you can see this. The emblem is very, very worn and faded. That's the downside. If it was clear, it would be really cool. You can see some part of it. I'm sure an expert knows what it looked like initially. But there we go. Okay. Anyway. Okay. Slamurai Jamdown asks, does gay butt shex make you gay? Asking for a friend who is not me. That's an interesting sort of question, because it's interesting in the context of like religious arguments about homosexuality and the boundaries of it, right? Because there's the idea that someone is homosexual or a same-sex attracted person. And then there's the idea of like an overt act of homosexuality, which they're different things, I guess, because one doesn't necessarily lead to the other and one doesn't necessarily follow from the other. There are gay celibate people, I guess, who don't engage in certain acts. I don't know if that's the proper thing for them to do or not, but there are those people. And then, of course, there are non-gay people who may engage in a homosexual act. So I don't know. I don't know what the answer to that is. Probably. We'll say probably. Andrew Shugit says, can you copyright a dance? Like all of my old Wisconsin aunts and uncles are pretty good at the standard polka waltz. Can it become illegal for them to bust that out at a wedding or family reunion? Well, I think the standard polka waltz is probably old enough to be public domain. But the answer to your question of can you copyright a dance, I think yes. You can copyright an artistic idea or expression that is recorded in a medium, I think is how copyright ends up working. So by creating the dance and writing it down or performing it on a video that is then saved and preserved, you have created a copyrightable work. Whether or not this particular dance is copyrightable is a good question. Like, what influences are there that led up to the dance? Did he just make it up on his own? Did a choreographer help him with it? Is it a collaborative effort or not? There are a lot of questions that we don't have the info for yet. Although we could maybe read into the document and see what their claims about it are. They seem to be claiming that Carlton himself made it up, and there are other issues. For example, typically someone who is hired by another company to work, when they create a creative work, they're actually giving ownership of that creative work to the parent company that's employing them. In this case, whatever production studio created Fresh Prince of owned the rights to Fresh Prince of Bel-Air that the creator would have then optioned or sold to them, they would have had the rights to any of the copyrighted material in the show, including the Carlton character. Like, Alfonso Ribeiro probably doesn't own the Carlton character. It's probably owned by the company that produced the show. Now, it does depend on what's in their contract, whether or not he gave up work for hire licensing rights or not. He could have had a provision in his contract that he created the character and the expression became his, and that various things would belong to him and not belong to the producer of the show. That's a possibility. Or if he was a co-creator of the original show and they licensed the creation, they may not own a lasting license in the content created out of the show. I don't know if he was. I think he was just an actor. But those are big questions. You copyrighted that argument. Those are big questions. You should know that lawyers don't play by copyright rules. They steal stuff from other lawyers all the time. Those are good questions. And I think some of the answers would probably be in that initial complaint. And we may go back to that later or, again, do a full video on it. But at first, I want to... First, I want to get through the news segment, and then we can talk further about it. Cormoran says, can someone with cerebral palsy copyright their walk if they walk across a dance floor? Maybe, I guess. Probably... if they did anything special in that walk, maybe. Maybe. But that's not the only part of the claim. It's not just a copyright. It's also the use of likeness or image to endorse a product. And I think that's maybe where they get really into some fuzzy ground, where Ribeiro might have a better case, might have a really good case on the use of likeness or image, because by calling it the Fresh, they're wanting you to associate that dance with Fresh Prince. Obviously it's in there for that purpose and that purpose only. The name gives it away. And that's what I was talking about before with the playfulness of Fortnite and the I guess, very laid back nature that they've taken with this. In doing so, they may have opened themselves up to liability by, casually referencing a 90s sitcom and not considering the fact that maybe someone owned that material. Carlton is an original character, unlike Urkel. Should people be allowed to copyright human, animal, plant genes? Oh, that's a long subject, buddy. Okay. But that is the Carlton lawsuit in a nutshell. Yeah, the backpack kid who did the floss dance at whatchamacallit, was a Katy Perry concert or something. He is also suing Epic Games. This is very interesting. And someone asked earlier, what does he expect to gain from this other than animosity? I don't think he expects to gain animosity, but if we take at face value what's going on. He has created something, and Fortnite is monetizing it and making probably a ton of money off of this dance that otherwise he could very easily argue would not be as popular. And it'd be interesting in Discovery to find out the sales difference between the Fresh dance and other emotive dances that maybe aren't based on some pre-existing cultural phenomenon. But there's a reason that they picked the floss. There's a reason why they picked the Fresh Prince dance. It's because they're recognizable. People immediately see them and they get images of Carlton. They get implications on what is meant by that. There's all sorts of baggage that's brought along with that dance that is valuable to the company. It's valuable to the purchasers. And most importantly, in this case, it's valuable to Carlton, right? Because that's money that has been taken from him if the dance truly is copyrightable. And if we take his argument at face value and he does own the rights to it, you know, they could be making tens of millions of dollars off of this dance. I don't know how much they sell it for. It's probably in the suit. But, you know, let's say they sell this thing for $1 and they sell 10 million copies. What did it take them to program that dance in? Not much. So they make a ton of money off of it, and Carlton should be entitled to a license for that if his article is correct, or if his lawsuit is true. We can dance if we want to, but leave your lawyers behind. Everyone wins in a lawsuit. All the attorneys do, that's for sure. Lawsuits are free money. Class action lawsuits can be free money for the attorneys. Tim donated and says, what Canadian whiskey should I bring to my upcoming visit to Minnesota? Canadian Club? Ooh, that's a good question. I don't know. I haven't had too many Canadian whiskeys. I've had Crown and Crown Black. I've had North Dakota Select, which was a Canadian whiskey. I've never had Canadian Club. Is it any good? I don't know much about Canadian whiskey. Something good. Bring something good. Who are you visiting in Minnesota? Are you visiting me? That'd be fun. Noob145 says, I'm pretty sure Backpack Kid didn't come up with his dance even. I think it's an older dance. That could be. And that'll change the question of whether or not, and he has a completely different case, I'll say, than Alfonso, because like the Floss Kid may have popularized the floss dance by happening to perform it while a camera was watching, with millions of people watching the camera. But if he didn't create it, there's no copyright there. And if he, who's Floss Kid, right? Like, you don't know, we don't know, I don't know him. I would say most people probably don't know him outside of the context of that dance. People know Carlton. People know, by extension, Alfonso Ribeiro. They know him. He's a personality. And by one of the claims that he makes, or that they allude to in the article anyway, is that he's saying they're basically falsifying an endorsement from him of the product. Like, look, even Carlton supports our product. This harkens back to there's some cases on this with a guy by the name of Tom Waits, I think. His style and voice were imitated in a Doritos commercial. And so he had expressly said that he was no longer doing advertising. And then Doritos did a commercial and asked him to do the part. And he said, no, I'm not doing advertising anymore. So they found someone to sound just like him. And then people started talking to him and say, hey, I thought you weren't doing ads. And of course he didn't. Someone else did. So he sued on the basis of this false endorsement, because they were clearly trying to evoke this particular singer by doing a mimicry of him. And there's another singer, Bette Midler, I think. Same thing happened with Bette Midler. I think she won hers and he lost his. But anyway, these lawsuits exist, especially when you've got celebrities and when those celebrities are being made to endorse a product that they don't actually endorse. And made to is given the appearance of doing it without their consent. So Oh, Tim. Okay. Yeah. I'm going to work to join you or something. Yeah, we'll talk about that in the Discord. I didn't, the difference in names from here to Discord. I didn't realize. Yeah, bring something good. That'll be fun. Okay. That's this story. All right. Let's see here. Here's the Carlton lawsuit. I'll put that up in the background while I get to the next story. Here we've got oh God, it's Polygon. I apologize in advance for putting a Polygon article anywhere. Ugh. Escape from Tarkov team. Barrage's YouTuber with DMCA takedowns over misinformation. Oh. Look at that headline. Oh, boy. Oh, that's going to be bad. If anyone impersonates me on a Fireball ad, we're going to have a serious lawsuit on our hand. Okay. All right. They say YouTuber Eroctic's content was both inaccurate and negative. Battlestate Games, developers of the multiplayer tactical shooter Escape from Tarkov, have issued nearly 50 DMCA claims against a YouTuber with the handle Eroctic. Rather than citing piracy or unfair use of content for monetization, Battlestate tells Polygon those claims were made because of incorrect information and overall negativity about their game. Oh, man. All right. Well, I'll have to see if Polygon does any reporting on the wisdom of those statements, but let's move on. Reached for comment, Battlestate said it had no other choice than to issue DMCA claims, which could result in serious legal issues for Eroctic, up to and including the removal of his channel from YouTube. The law, which is broadly written, tends to support these kinds of actions by game developers? I don't think so. We're gonna reference that article in a minute. I mean, if that's the case, holy cats. Eroctic. If this gets to Eroctic, if anyone wants to clip this, I don't know anything about this guy, but if anyone wants to clip this, I think I know an IP lawyer who would love to take this kind of case. Maybe not, but I think so. False DMCA claims. DMCA claims based on anything other than an actual infringement of copyright without regards to things like fair use, especially by a big company that is admitting that they're not doing what they need to do. Holy cats. What a great case to have. Oh, and the reward for this is attorney's fees. Attorney's fees plus any damages. And I don't know who's Eroctic, by the way? Is anybody familiar with this guy? I'm going to take a peek at his channel. 50,000 subscribers almost. Great job, buddy. Oh. Let's see. He made a 15-second video called My Side of the Story. I don't know if that's a meme or something. Man, I would love to talk to this guy. So if anybody has a line to Eroctic, I would... That'd be very interesting to see what would happen. He was on Leonard French's stream. Curse you, French! Curse you. I don't know what French said about it, but... Okay. The confrontation between Battlestate and Eroctic stems from what the developer says was a pair of inaccurate videos. A pair of inaccurate video. Apparently Polygon doesn't know the plural of video. Claiming that user information, including passwords and personal information, had been leaked from the company databases. Battlestate claims the misinformation was damaging to the company and had to be dealt with quickly. Well, that's not what DMCA is for. The reason why we acted so strong and so quick is that we had to stop this misinformation about the data leak, said a representative of Battlestate's public relations team, in Russian and through a translator. Following the claims, these videos are no longer visible on YouTube. Gosh, I hope he counters that. Right now, we are reviewing all of the videos which were copyright strikes. If we find that those videos have no issues with the law and the negative rhetorics, we might call back our strikes. Let me give you some non-legal advice, Battlestate. And I'll speak Russian for it. Comrade, callback strikes will be okay. Will be okay. You may have defamation claim, not copyright. No, don't do this. It's not good. Not good look for you, fam. Not good look, not good outcome. Abusing wrong legal process goes very bad in US courts, okay? A post on Erotic's Twitter account indicates that at least 47 of his videos had DMCA claims made against them over the weekend. Battlestate probably had to get a temp just to do that. Battlestate said that while information was okay, was only part of several of those videos, negative hype was present in all of them. For that reason alone, they say they are justified in executing the takedown claims. Woo. I don't know what lawyer they got. Maybe it's Michael Flynn's attorney. Many videos with escape from Tarkov content in them remain on Eroctic's channel. During a broadcast today on Twitch, Eroctic said that he has created more than 300 YouTube videos on Tarkov, and that between 80 and 90% of his channel's more than 2 million views can be attributed to that content. The support for Eroctic on social media has been extensive. A so-called emissary, Battlestate's term for affiliated content creators in the US, has resigned. OnePegMG even prepared a 15-minute statement about his departure. Quote, on December 13th. On December 13th, Battlestate Games was a developer making the best shooter that the world has ever seen, in my opinion, said OnePegMG. On December 17th, Battlestate Games is now a developer that has levied a series of DMCA claims against a YouTube personality to the extent of which there is no precedent domestically or internationally. I don't even know what that means for him, but okay. As is my understanding as to the appropriateness of this action. Well, I mean, no. But precedent doesn't apply. Like, the DMCA is the Digital Millennium Copyright Act, not the Digital Millennium Bad Press Act. They stopped being a video game developer with a beautifully crafted product and started to become a developer that will make an example of you if you took things too far. Another content producer who goes by the handle Clean said that he is no longer comfortable creating the popular Talking Tarkov podcast. Battlestate's representative said that due to what they consider to be the damaging nature of Erotic's videos, their organization was left with no other choice. I mean, well, you did have a defamation lawsuit. Like, that's your other choice. Or you could pay him off. Or you could make your game better. Or you could put out your own video. I mean, you've probably got a bigger audience than him, I would think. Quote, we've been following pretty much all the creators' videos and all materials which are uploaded in the web. No, don't do that. Don't do that. A representative told Polygon. We didn't react to a lot of negative criticism, but in this particular case, Erotic has crossed the line, and we had to act hard on them. The thing is that we cannot allow this information, this false information, to stay on the web. Whew, if only it were that simple, right? But even as Battlestate admits, only 2 videos contain information about rumors of a security leak. The other 40 plus videos that it issued DMCA notices against did not. Rather, they pulled them down simply because of the tone of their content. We know that what this instrument is designed for, said a representative referring to the DMCA claim system. We had to use this tool in order to stop this wave of misinformation. No! No! to inappropriately appropriate Killstream. Now, wait a minute, Battlestream, no! Don't. Stop talking. Stop talking to Polygon and saying this. What's important to be noted is that we didn't ban this person in-game. Oh, that matters. We still allow him to play and to stream on Twitch because he never cheated, he never broke the rules of the game, and he never broke the rules of the license agreement on the game. But in his videos, he spread a lie, and we had to act fast and stop this. Oh, boy. Yeah, it'd be easier to have Putin polonium this guy than it would be to do this. What are you thinking? The representative said there's not currently a formal policy in place for content creators regarding what is and is not allowed to be created with footage from Escape from Tarkov. Well, there's your first oversight. Polygon asked if they feel that they may be overstepping with the scope and scale of their actions, that this could cause a chilling effect on YouTube. No, it could actually cause a nice payday for erotic in a weird way. Or even if it doesn't, some lawyer will make a bunch of money on him and put, I mean, the battle state could, you could lose the whole development of this game because of an action like this. They could lose that much money on legal fees that they would have to pay their own attorney. Plus, they would have to pay his attorney when they lose, and they will. They will on something like this. Whew. Eric Blum. No, I don't use ad block. Why bother? Why bother? Let's give Polygon ad money. Let's see. We understand that other content creators are worried about this, the representative continued. But through all the years of development, it's the first time when we use DMCA claims to the content creator. We're not going to do it anymore. We wanted to show that negative hype and misinformation cannot remain without any punishment. Yeah, these guys are definitely Russian. The game and this community do not deserve that. Rather than issue DMCA claims in the future, the Battlestate representative said that going forward, they will instead employ more traditional lawsuits for things like defamation. It's not about making content, they continued. It's about false accusations. It's about lies. It's about misinformation. Oh my God. Every one of these statements can just be plastered into the lawsuit. And they can, someone said lawsuits are free money. Yeah, you could just print this one. You'll go ahead and win it very quickly. Whoa. Whoa. We don't want to scare off anybody. It was applied to only this person and only in this case. Battlestate also, we don't want to be nuking other people. Only this guy. Only him gets Sarbumba. Battlestate also issued several statements on Facebook, which appear to put the community on warning. Quote, we understand your negative attitude regarding this situation, reads the post, but we urge you to take a comprehensive approach to its assessment before moving on to a new wave of accusations. Polygon has reached out to Erotic for comment. Woo-hoo-hoo-hoo. Oh my gosh. Let's okay, Polygon. Let me offer some criticism before Polygon DMCAs my video. Polygon really should have taken just a moment to talk about the serious ramifications of abusing the DMCA system, which is meant exclusively and expressly for the removal of copyrighted material that is reproduced without a license. This article in Battle State's statements lay out a clear case of an improper DMCA. Eroctic would be entitled to any damages he suffers that he can prove. As far as going further than that, there may be a punitive damage because of the scope of what they did, the publicness of it, and their statements that followed talking about what they were doing. A judge might not like that. But either way, you're talking tens of thousands of dollars in legal fees that they would win, I would think, handily. And the background of this is actually Universal Music Group. This is a case I do intend to go through in the future, but Universal Music Group was DMCA takedowning basically anything that had any of their copyrighted material in it. So a woman took a video of her kid dancing to a Prince song in the background, and they DMCA'd that video automatically because they own the license to the Prince song. So the woman took them to court, and then in that court process, she won handily. And what she won was basically the court saying that Universal Music Group, in using the DMCA process without doing a proper fair use analysis in good faith to determine if they should do a DMCA claim, was therefore abusing the DMCA legal process, and they lost. And then that was laid out as the way the law is applied. And so now when you're doing a DMCA claim, and YouTube will prompt you for this, it says, have you considered the possibilities of fair use? Have you done a fair use analysis? Here is our section on fair use, and you can read more about it here at copyright.gov or whatever, and you can learn about what fair use is if you have questions about it. Universal Music Group didn't say that they didn't know what DMCA was or what fair use was. They said, no, we just didn't do it. We didn't do the analysis because we didn't feel it was necessary. I mean, Battle State, of course, the case is slightly different, but from their statements, it sure doesn't look like they did a fair use analysis because they're not basing this on copyright at all. So how could they analyze fair use if they're saying we're just taking down negative opinions of the game? Unless they have a copyright on the negative opinions. That'd be a funny argument. No, only we can talk crap about our game. Oh my goodness. Tap House Gaming says, new Patreon here. Thanks for all the stuff I listen to while at work. Have a drink on me. Thanks, buddy. Welcome. Glad to have you. Thank you for joining the Patreon. I'll look forward to chatting with you in the Discord. And thank you, of course, for the chat. Hey, what's up, Hikaru? All right, so I think Polygon maybe should have reached out to... you could even reach out to a commie lawyer who reads Polygon. It doesn't matter. Just talk to any IP lawyer about how damaging this is. They should have reached out to a lawyer and just said, hey, can you just talk about what this looks like? Because this looks like a really bad DMCA claim. Opens Battle State up to severe legal liability, at the bare minimum, attorney's fees. So Eroctic, he would have to hire an attorney. He'd probably have to pay them in the initial retainer, but he could recover anything that was paid as part of a victory in the lawsuit, plus any damages that were out there. We'll have to see what happens to his channel. I mean, if his channel gets shut down, or videos get demonetized or whatever, he could, and for all of the time that they are shut down, he would lose money. So those would be provable damages. But Landon Mack and James says, on the way home, don't drink too much without me, Nick. Yeah, buddy. Marsupial Gamer. Interestingly he says that I got to get off Patreon. They need to die in a fire, figuratively speaking. Their house needs to burn down in Minecraft or whatever. I am starting to work, like, not in the way that Dave Rubin and Jordan Peterson and all those guys are working. I'm working on an alternative for Patreon for me, not like for a big group of people, but people have self-funding mechanisms, and I've got a friend who's a developer, and I'm looking to create a space that will offer many, if not all, of the benefits of Patreon, but cut them out of the equation. And I'll be working directly with a local merchant services provider, ideally. And so we would be cutting out these deplatforming companies and just allowing money to flow from A to B with as little interference and as little speech interference as possible. And then the main things I need are things like Discord integration, reward tiers, and all that stuff. The stuff that Patreon provides, but taken off of that platform. I would love to do that, and I'm working on it at some point. But, you know, the stuff takes time, so bear with me on that. I really hope Patreon changes its mind on how it's acting, but it is very inappropriate. So, that's what we're, hopefully that's what we're going to have at some point in the future. And it's probably the way we have to go. Cammy Killer says, keeping me entertained during my overnight shift at the college radio station. Keep it up, Rackets. And then Tillip says, I would totally buy shirts if you sold them. Yeah, shirts. It's almost like someone I know talked to me about doing shirts, and then I dropped the ball on actually selling them. Would you guys like some shirts? I think I can make some shirts happen. Well, yeah, my nose is red like a drunk cartoon character because it's hot. It's hot in the vault. If you don't know, my office is a vault. Here, look. Literally a vault we're in. So it's hot in the vault. I'm drinking, getting worked up a little bit. It's also Christmas, and Rudolph is my spirit animal, apparently. Rudolph's my first Sona, maybe. But yeah, so I do. Tillip knows I've got a shirt design that's been done. I'll see. Streamlabs has a store, and I'll put it up there. How's that? And then I'm working on mugs as well. Landon Mack and James says you should collab with Legal Eagle, please. Awesome, dude. Bruh. My kids all say bruh. Marsupial, I was going to do crypto fashion, but I have to do like I have to apply with them. And then the Streamlabs has, Streamlabs has a merch store that lets you do more than just shirts, like right in the thing. It's very streamlined and it's very easy to access. So I don't know. I have to decide. So, oh, guys. Don't make me start cursing at the chat for mentioning Legal Eagle. The racket shot glasses and tumblers are a thing I want to sell, and they're not actually sold, I don't think, on Streamlabs yet. So I do have to find something for that. I've been saying it for a while. I'm working on this stuff. Guys, I'm just really busy, which is not a good excuse, by the way. I'm not saying you should respect my time. I'm saying that things just kind of go out of my mind because I'm doing all this other stuff. I will work on it. I promise. I promise to work on it. And it will not be a New Year's resolution. Hopefully it will be a New Year's solution. So we have it by then. Yeah, Tillip, the mugs are your bad. How dare you, good sir. Okay. The bayonet goes on the lake as soon as I affix it to the gun. All right, what do we got now? Yeah. We were going to talk. Oh, I was going to read this other article on Polygon real quick. Because they said that DMCA this is an effective tool for video game companies. Let's talk about that. Let's check this out. Mona Ibrahim is a senior associate at Interactive Entertainment Law Group. She's an avid gamer and has dedicated her career to counseling the video game industry and the indie development community. On Twitter, Mona Ibrahim. So Mona Ibrahim is a lawyer who works for Polygon. I mean, I disagree with the title of this, but let's see what we've got. All right, here we go. Campo Santo co-founder Sean Vanneman, writer of Firewatch, has made his feelings known about a live stream broadcasted on Felix PewDiePie Shellberg's channel where he used a racial slur. Did he use a racial slur? Well, obviously, if he used a racial slur, everything he's ever said is invalid. How dare you, PewDiePie, be such a Nazi? However, he's also triggered... They could have just stopped there, I think. A debate on the respective rights of streamers and content owners by promising to issue a DMCA takedown for any PewDiePie video using Campo Santo content. No, this lawyer should know that that would be, that statement by itself. We're filing DMCA takedown of PewDiePie's Firewatch content and any future Campo Santo games. Boom. Automatic. Like, PewDiePie wins that lawsuit, and this person should know that. This has become another impetus for an ongoing disagreement concerning the legal standing of Let's Play streams and videos. In my role as a video game attorney, this presents an interesting question for my clients. Who's her clients? So this is something you have to do with lawyers, right? You have to do this with lawyers. Is you have to analyze what perspective they're speaking from. Now, she is a video game industry attorney, right? Her advice is to her clients. Her clients are video game developers, not consumers. From the impression that I've got so far, based on her bio and how she's talking about this. What's the best approach to handling this new marketing tool while protecting the game's brand and content? Vanneman's approach in particular has set off serious debate, as his tactic may be seen as an abuse of the Digital Millennium Copyright Act. But from the perspective of the content owner, Vanneman's reasoning is irrelevant. You see, a licensor doesn't need a reason to withhold a license. That's true. The question is not whether or not they have a reason to, or that they've even issued a license. That also means they can withhold a license for any reason. In the case of a Let's Play video, a content owner like Campo Santo would argue that they can revoke their permissive, non-exclusive license to stream granted to end users against anyone who uses their content in a way they find offensive or in a way that associates their game or brand with something against their values. But that doesn't actually matter because you don't need a license for fair use. Fair use goes beyond copyright, and fair use, this is an important statement about fair use, okay? From, I believe, the Supreme Court. If not, it's one of the appellate courts, and I don't remember the judge's name. I apologize, Judge, for not properly attributing this to you, but I don't really want to look it up right now. He said, fair use is not something defended by copyright law. Fair use is something that is encouraged and specifically created in copyright law. That's a paraphrase, not a direct quote. But what he's saying is, like, fair use isn't like, well, this is fair use, so we guess the law will allow it. Fair use is a new creation that then is protected. It is not derivative work. Fair use is the creation of something new by sufficiently transforming something that exists. Okay? It's encouraged. It's contemplated, it's encouraged. It's not a byproduct. It's not a stepchild. It's not an aborted baby from Detroit. It's nothing like that. This is the product that someone is delivering with a Let's Play video, technically. Because PewDiePie, especially a PewDiePie, people aren't watching the game for Firewatch content. People are watching PewDiePie for his Firewatch content. Massively different. Massively different. Especially because his audience is 10 times bigger, at least, than Campo Santo's audience. So this is not, I would argue this is inaccurate. This is the approach Vanneman has taken. He doesn't want his studio's game associated with Kjellberg's channel or content, which is arguably a perfectly legitimate basis to withdraw a license for which you need no legitimate basis to revoke. Yeah, that's fine. He can issue a letter that says, I withdraw the license for you to stream my game. And all PewDiePie has to do at that point is significantly transform the copyrighted work, which if you're talking about a video game with presumably hundreds to thousands of hours of content that have been created, it's really easy to argue a transformative use by having a 1 hour Let's Play. Because no one watching the video, no one watching the Let's Play is getting the full experience from your typical video game. Unless it's a complete walkthrough and the person doing the walkthrough doesn't say anything and just plays the game straight through, start to finish, and it's linear and has no alternative endings. But in any game that people are typically doing Let's Play videos on, you're talking about only experiencing a fractional portion of what's out there, what's created. Like, you can't say that watching a PewDiePie stream gives you, like, oh, I no longer need to buy a video game because I watched some dummy on Twitch play it. Like, you might determine that if you think it's a bad game, but not because you've fulfilled the content and have sufficiently replaced their creative work with whatever PewDiePie or any other streamer did. So this is a silly, like, it's a half argument at this point. Under copyright, an author's underlying justification for bringing an action carries very little weight unless the claim lacks merit. If, as most of my clients believe, Let's Play is not fair use, well, I'm sure your clients believe that. That's not the question, though, is it? Vanneman could issue a takedown for any reason or no reason at all, and as long as there is still actual infringement, an argument of bad faith probably won't have much of an effect on the outcome unless you get a very sympathetic judge or jury. Unless you've made statements that you're automatically issuing it without a fair use analysis because you don't believe that fair use works. Come on. What's your name? Come on, Mona. Come on, you know that. And for practical purposes, that's where it ends. Practical purposes is most people can't afford it. I would love PewDiePie to start suing people. PewDiePie can afford it. Except Firewatch in particular only has about 5 hours of straight linear gameplay. Well, whatever. Siren Jag, how would playing the game be against their values or offensive? Maybe they hate their own product. This person is the worst lawyer this side of Greer. She turned left at the corner of Greer and Eigel. No, she's probably a good lawyer. She's just actually advocating vehemently on behalf of her clients, but she's doing so in an article that is labeled as journalism. There's a big difference there. Influencers rarely fight takedowns unless they have the money and willingness to defend their use. Yeah, go ahead and say that some more. That'll help your clients. Even if there is a fight, it's short-lived. From a lawsuit timeline perspective, it's always dragged on too long for both parties. And these cases always seem to settle. Chances are this will too if it comes to that. Yeah, you'll demonetize PewDiePie and then you'll recompensate him for the lost revenue. Terrible plan on someone like him. Good plan on someone with very little money coming in. I gave a talk at PAX West this year and touched on this subject. Did you have the consent of the subject to touch on it? It covered user-generated and fan-produced content in the context of what is and is not okay. Uh-oh. This is not okay. What if they claim copyright on the racial slurs? Content owners have a strong leg to stand on in terms of IP protection when it comes to Let's Play, but the industry's willingness to embrace this new form of content curation and delivery early on has meant that many, particularly fans of Kjellberg and his ilk, have confused permissive use with fair use. Oh no, I think you're just wanting them to think that way. The informal system right now is actually pretty good. Oh, you commie shill. It's important to remember here that all intellectual property law is censorship in some way, shape, or form. It's designed to allow copyright owners an opportunity to prevent others from using their content. If my clients elect to permit streaming, listen to the presumption of this. You don't get to choose what people do with your art. You only get to choose it if they infringe on your copyright. But other than that, I mean, I would say streaming is definitely transformative. Definitely. Out of, except for very rare circumstances. That's a business decision and has little to do with any perceived claim of fair use by the Let's Play community. As a fair use determination is made on a case-by-case basis, the only way someone can conclusively show that Let's Play qualifies for fair use is to litigate it. There's a very good reason no one stepped up to the plate for that. The fact that Let's Play videos are predominantly commercial for entertainment purposes and borrow substantially from the original work product weighs against a finding of fair use under the 4-factor fair use test. Well, oh gosh. I hate the slant. I hate the slanted perspectives. Don't call me a racist. I hate the slanted perspectives. To refresh your memory, or if you have no idea what I'm talking about, courts consider the following 4 factors when making a fair use determination. Purpose and character of the use, the nature of the original work, the amount and substantiality of the portion used in relation to the work as a whole, and the effect of the use on the market or potential market for the original work. Well then, there's a massive body of academic and legal discourse on the subject of fair use, all of which is relevant and all of which will remain the subject of academic debate until Let's Play is litigated. No one in this business on either side is eager to see that happen. I don't think that's true. Content owners are satisfied with their protections, DMCAs, streaming guidelines, etc., and don't want to potentially expand fair use to encompass even some, let alone all, Let's Play streams. Influencers and streamers don't want to test those legal waters either. They're perfectly happy with the silent or active permission afforded by publishers and developers. Fair use gives them a negotiating chip they could lose if Let's Play is litigated, but has never really been tested, and it won't until it goes to court. The longer you wait, the worst case you have, lady. Siren Jag, good night, buddy. Hope you get better. Migraines suck. What about the Nintendo Creators Program? How is that legal? They're ending it finally. I don't know. I'm not familiar enough with it. Hamilton Burger, there's a good reason nobody has stepped up, but not the reason she thinks. I think that is probably the case. The only ones who want to see litigation are fans, lawyers, and hecklers. No, that's not true. That's not true at all. Content creators want to see litigation. They can't afford it. They can't afford it. And you're preying on that, and that's disgusting. At this point, it's safe to say that Vanneman's approach likely has legal merit. I don't think it's safe to say that it likely does. Although the ethics of using the DMCA as a form of public protest are questionable. They're not questionable. They're wrong, and you know it. You know it. Stop lying. In rare cases, there are counterclaims and lawsuits specifically designed to prevent strategic lawsuits against public participation. Yeah. Which prevent defendants from carrying the financial burden of defending a meritless lawsuit if that lawsuit is designed to censor the defendant or otherwise prevent the defendant from engaging in public discourse. I wonder if anti-slap could be applied to a false DMCA. That'd be interesting, because you're admitting to trying to use it for censorship purposes. In other words, if a copyright owner sues you and you bring an anti-slap claim, you're entitled to damages if a court finds that the underlying action was brought solely for the purpose of suppressing speech and otherwise lacks merit. However, the problems with anti-slap are it's not available in most jurisdictions and is only enacted by statute in a handful of states. Hey, lady. That EULA that you force all of those streamers to abide by to use the product, that license agreement, what's your choice of law provision for your clients? Is it California? Because if it's California, I got news for you. Where a lot of game developers are, Silicon Valley, they have really good anti-slap laws. And you might have a choice of law provision that requires the end user to submit to a California court of jurisdiction. I don't know what your clients have, but that seems pretty common. It can be superseded by federal law. Well, any state law can be superseded by federal law under the Supremacy Clause. The underlying suit, e.g. a suit for copyright infringement after issuing a takedown notice, has to lack merit, and proving that requires exposing yourself to the risk of litigation in the first place. Does it? I mean, you just by streaming, you expose yourself to the risk of litigation is what you're saying. Anti-slap claims are rarely successful. Tell that to Donald Trump, baby. Tell that to D. Trizzle. This is a long article. Oh, we're almost done. It's worth noting that the lack of an anti-slap statute in the jurisdiction where the matter is litigated could play into whether a defendant influencer is willing to litigate in the first place. It's not common and it's difficult to enforce, however. So in most cases, anti-slap is treated as an exception rather than the rule. Except you've just admitted that game developers, especially ones who have publicly tweeted that the purpose is censorship of speech, not protection of copyright. What is this? What company is this? Firewatch? What is Firewatch? Hold on. I got to find out about this. Let's find out. Firewatch EULA. Campo Santo. Nope, that's not the website I want. Okay. Where is it? Oh, are you kidding me? Like, does Firewatch Campo Santo TOS? What's your terms of use for this game? Where's your EULA? You're talking about revoking a license, but what is your license? What license agreement are they violating? Hold on, I'm trying to find this. Streaming and Let's Plays. Streaming and Let's Plays are implicit but revocable privileges, and if you happen to be among the very, 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 very few players who use our platform to spread hate or harassment, we would prefer that you not use our games in your content. Oof, we didn't. This isn't an EULA that's enforceable. What are you talking about? This, oh my God, what a disaster. If this lady is Firewatch's lawyer, this is shameful. Okay. Here's the problem with this. You're talking about issuing a license and they can revoke a license. Sure. But what's the license agreement that they're violating? Like, you can't just revoke a license that someone paid for. I don't think. Like, at the time money's exchanged, courts look at that and say, okay, wait a minute. They exchange money to play your product. You can't suddenly revoke that license. I don't know that they haven't articulated a terms of service. They haven't articulated a terms of use. They say things like, we prefer. What kind of cuck hippie language is that? This is law, baby. You put it down. If you use hate speech or harassment in your content, you are not allowed to use our products. We will revoke this license. Done. What are you doing? What is this? What is wimpy garbage? I can't take it. She's here. Here this lady is laying out like elaborate licensing issues, and they don't even have a terms of service or a EULA that the content creator would know they're in violation of. Presumably. I don't know. Maybe if you buy it, you get an EULA, but it's not available on their website. What are they doing? This is a terrible plan. It's a walking simulator. Yeah, that's another question. Is their work actually protected or is it derivative? That's a good question too. All right. One last legal consideration is the role of the service providers in determining fair use under the takedowns procedure has shifted in terms of maintaining their ability shield in some jurisdictions. The Ninth Circuit recently ruled in Lens versus Universal. Hey, I just talked about this. Good job, lady. Way to go, Mona. That service providers like YouTube and Twitch, no, may need to consider fair use before taking down user-generated content. No, that's not what they ruled. What are you talking about? They ruled that Universal, the content owner, needs to consider fair use before taking down user-generated content. The practical application of this ruling, however, is anything but clear. I mean, I guess. There are precious few bright lines when determining fair use, so service providers are still better served by ignoring fair use except in the most obvious cases. Ethics influence the law, but not all ethics are legally enforceable. In this case, an argument that Vanneman's use of DMCA takedown notice procedure is preceded by the First Amendment depends on whether he needs a reason to withdraw permission in the first place. No, but that's not the argument. You're missing the argument. The argument is that they would apply a DMCA without first conducting a fair use assessment and for a non-copyright issue under Lens versus Universal. That's the question. Under the DMCA, infringement is infringement, regardless of either party's intent. Fair use, however, is not infringement, which makes it the best available defense for First Amendment fighters. Right. This is all fair use. How would this hold up in court? It isn't clear that the Shield can offer Let's Play videos much legal protection if it's ever fought in court at this point. Oh my gosh. Guys, picture the judge who rules that a Let's Play video is not fair use. That a Let's Play video that, definitely relies on the contributions of the streamer exclusively, because you can put PewDiePie next to anyone else playing a game and show that the content created by PewDiePie matters more. The contribution matters more than any other person streaming by a significant amount. And that if PewDiePie's video gets 8 million views in a day and the other guy's video of the exact same game, and Firewatch is a prime example because someone said it's a 5-hour linear playthrough. Okay, perfect. So PewDiePie's stream versus anyone else, you've got 8 million views and you've got maybe 10, 15, 30, 100,000 views, whatever it may be. Are you serious? You're going to argue that Firewatch is what people are coming to see, that that's the use in question and not PewDiePie? What are you talking about? Why? Anyway. Okay, let's see. As I mentioned before, all intellectual property law is effectively censorship. They give content owners, investors, and creators the exclusive right to prevent others from using their work. Every copyright owner has that right. However, this is by no means absolute. Balancing IP rights against the First Amendment rights has been an ongoing struggle for jurists. I'm proud of the solution our industry, the video game industry, came to when confronted with Let's Play. We didn't seek to suppress. This is a paid shill of the industry. This is gross. You're working for the man. What kind of lawyer are you? Actually, I'd work for the man too, but, We didn't seek to suppress, crush, or control it. Yes, you did. Which, as we saw when the music industry went after digital distribution. What? Okay, first of all, the way the music industry went after Napster was terrible and stupid. However, the free distribution of music versus watching someone else play a video game are vastly different things. Come on now. Is perfectly valid legally, but also a really terrible idea in terms of public image. It's not perfectly valid legally. If people were think about this. This dummy is out here saying that the video game industry is not going after people distributing their games via torrent of course, of course the industry responds in the exact same way that the music industry did when you're torrenting a video game and they can identify the torrent source or the torrent consumers. They're definitely taking action. Absolutely. Streaming content is not the same as music. This is interactive content that when you watch a streamer, you don't get to interact with. The industry instead focused on making Let's Play collaboratively and mutually beneficial. Yeah, that does not mean that content owners gave up their right to say how fans can exploit their content. Content owners didn't have a right to say how fans exploit their content, so long as they're within the legal bounds of fair use. Can you link me that game torrent? I actually am such a boomer, I have no idea how to do that. I just know that torrenting is a thing. This also does not mean that Let's Play is protected under the First Amendment. Oh, baby. I got news for you, lady. You're talking about an interactive medium and taking away the key factor, the interaction. Only a court can make that determination, and the weight of legal precedent generally leans in the opposite direction. I don't think so. Movies and music are completely different animals. Like watching someone watch a movie, you end up watching the movie. Either way, like if I watch Mystery Science Theater, I'm definitely watching those movies because they're on Mystery Science Theater. But at the same time, I am consuming the entire movie product. Now that might be fair use. I think they don't fight over those things. They don't tend to take new movies on like that. And they've since moved on to riff tracks, which is completely different, and got around even the question of licensing. But this is different because I'm not good at first-person shooters. So watching someone else play a first-person shooter is, especially someone who's good at it, is wildly different than my experience. It's absolutely transformative to the product I would buy. All you have to do is show these numbers to a judge. Let's see. It does mean that developers and publishers, while not obligated to do so, are willing to step up and afford streamers an opportunity to use game content in new and creative ways. That's like saying Saturday Night Live has the opportunity to use the exploits of celebrities in new and creative ways. They'll just allow them to do that. Of course they have the right to do that. This has so far been the solution that has best served the community and the industry. Oh, no. It is not best serve the community. Litigating this out would best serve the community, in my opinion, because I'm pretty sure that YouTube creators would have a really good case. And if they won, imagine if they won. Imagine if Sargon won this case and he could go on a video game and he could rename every enemy white N-word and shoot all of them, right? Like, imagine if Richard Spencer could do a Let's Play where he runs around and shoots all the black people in America on Grand Theft Auto or something. Like, just imagine what they could do if they won. Content creators would make a fortune off of this stuff. Good Lord. Right now, we all sit as creators, as people on YouTube who don't own some sort of property, at the mild mercy. Like, Polygon could do a false DMCA against me for going through this article, and I would ultimately prevail, but in the meanwhile, I would get a strike and take damage to my website, or take damage to my business because of their false claim. They hold us in a stranglehold, and my only retribution against them would be is if my video or if the content that I lost out on were significantly damaging to allow me to take it to court and make it worth my while to pay an attorney to do so. I mean, YouTube personalities and Twitch streamers, they sit at the mercy of these industries right now, and we all know it. If you don't know it, you're crazy. But we all know it. So no, it's not mutually beneficial right now. It favors you because you guys have the money and the average streamer is trying to feed a family. That's different. Or feed, well, maybe not a family. Maybe the average streamer doesn't have a family. I don't know. But they're trying to feed themselves at least. Pay their rent, make ends meet, pay their bills. They don't necessarily have the time and money to just throw at something like this. It's unlikely that Vandeman is abusing the system. No, that's wrong. He's just testing the limits of the mutually beneficial ceasefire. That's one way to characterize it. You're a good salesman, Mona. Legally, what he's doing seems safe, but it's a slight shift in the usually agreed upon relationship between developer and streamer. The actual shape of that... I would love PewDiePie to start destroying these people. Gosh. If he didn't want to wield the power he has in the way that he does, man, he could just rip these guys apart. The actual shape of that relationship would have to be tested in court for anything absolute to be argued. And litigating Let's Play would almost certainly result in more confusion and presents the risk of destroying Let's Play as a medium. Why take that risk? Oh, there you go, guys. If you want to know anything about this opinion, that sentence, that pair of sentences tells you everything you need to know. This is an industry lawyer with an overt industry bias who blithely states that the industry is acting, the industry did nothing wrong and never done nothing wrong, never will do nothing wrong. And then the final sales pitch is, it would almost certainly make it more confusing. It presents the risk of destroying your thing that you have, that nice thing that we let you have. You might mess that up. Why would we take that risk? This is mutually beneficial, right? Imagine a used car salesman, because that's what lawyers are, right? We're used car salesmen. Imagine a used car salesman saying, hey, you know what? Buying this $10,000 car, sure, it's economical, it's affordable. It probably works just fine. It's a reputable brand, good model. But this one is $18,000. Looks a little bit better. I mean, if you buy the $10,000 one, I mean, it's got like 20,000 more miles on it. That could cause you engine trouble. I mean, who knows? Why take that risk? Buy the sure deal, right? Like that's how you have to look at this. That's what this person's doing. And it's a little transparent and kind of embarrassing. Senior associate at Interactive Entertainment Law Group. Hey, Moni Ibrahim, come on my show. Talk to me about this. I disagree with every word that you posted. Oh, God, all of it. I disagree with all of it. Okay, so there's that. That's where we are on this stupid Escape from Tarkov thing. They're on shaky legal ground. It should be litigated. Absolutely should. It should be litigated by someone with the money to do so. That's the only problem with this. If you want to know why it's not litigated, it's because streamers cannot afford to dump $50,000 to $100,000 plus into one of these lawsuits. There's just no way. No way they can afford it. That's what I say when I'm cucking a dude. This is mutually beneficial. Yeah, that's right. Exactly. All right, next we've got, let's see. Trump immigration. Oh, Vox. There we go. I guess we'll use CNN. I hate CNN, but man, I hate Vox articles even more. So let's talk about this. Oh, by the way, tomorrow night, for any of you guys watching that may be involved in the Comicsgate community, I want to just remind you guys that tomorrow night we will have Mindy Wheeler's ex-business partner on the stream for an interview. We will be talking about some claims that Mindy Wheeler made about this gentleman when they co-owned a comics book shop. Specifically, he has taken issue with her statement that he, quote unquote, skimmed comics from the shop. That is I assume, some sort of embezzlement, she has claimed. He is disputing that. He's very offended by it. And he says that the Wheelers are not liked in the comic book community, and he will tell us why. So if you have come to my channel from Comicsgate, I don't like dwelling on drama. I would much like to dwell on legal issues within Comicsgate. But I did have someone on my show, and then something was said about them, and then that person reached out to me and said, hey, I have been mischaracterized. This is not who I am. This is not what I did. And I want to tell my side of the story. I'm going to give that person the opportunity on any subject to certain, like if someone has ever been, they feel maligned on my show, I'm of course going to give the contrary opinion. I'm of course going to give the person a platform to discuss it. That's open to all of you people. I know it was hard to follow the chat yesterday, but someone seemed to imply that I am biased towards Andy Worski in the Killstream Andy Tonka drama that's going on. And personally, I will admit I lean towards Worski on this just because I've had more interaction with that side of the crowd than the other side. That said, I have told Tonka, I have told Failure, I have told other people that they are welcome to come on my show. We just need to set up a time to do that. I will not have someone come on my show and malign someone else without giving them the opportunity to respond. So if anyone thinks that like I'm just in the tank for Worski and won't give the other people a platform, that is not true. That is not a true statement about me. And if you have that impression, if that impression has come across to you, if you're the subject of this, I apologize. That might be my failure, or that might be the failure of someone you're reading who's not me. I don't know, but I'll take responsibility. If anything has been said negatively about someone on one of my shows by one of my guests, and they want the opportunity to contradict that, all you need to do is contact me, and we can set that up. So, Mindy Wheeler's ex-business partner has contacted me. We have set that up for tomorrow night live stream. I just wanted to make sure people know about that because it could be interesting. It could be a disaster. I don't know. I don't know anything about this person other than they have given me enough evidence to be confident that they are who they say they are. And we'll hopefully have an interesting discussion. So if you know Comicsgate people, if you're interested in this discussion, please share that tomorrow and make sure people show up for the stream. Landon Mackinjames says, please tell me Lady Rackets likes anime. Nick, yeah, I think she's fine with anime depending on the anime. So Russell Greer is welcome on my show 24 hours a day, 7 days a week. I would drive home from Alaska to stream Russell Greer on my show. Russell is 1 billion% welcome. 1 billion% welcome. So, there you go. All right. So here we go. Let's see. What's next? And it's funny. I have to tangent on this a bit. I talked about this at the beginning of the stream. But I love getting criticism on Twitter from people who have clearly never interacted with me and never worked with or never watched my show, because they'll say stuff like that about me, or they'll say that like I will give you an opinion and talk up my own knowledge or something like that, which is not true. I try to be very upfront about where my practice areas are, where my expertise is lacking, and I bring on intentionally subject matter experts when it is far outside of my scope, or I think we just need someone with more experience than I have on any issue. So it's this frustrating part of that I'm learning. Like, don't take this the wrong way. I'm not like tooting my horn here. As my life transitions to one more and more with more and more public exposure, I have to deal with more and more idiots, right? And like that's it's this weird product where based on one or two opinions that you might give that is contrary to what someone else's view on a subject or even their worldview is, they will then try to judge all of you in that way. And it's really tempting to find that unfair and to lament about it. And I'm not trying to do that here, although it probably is coming across that way. But it's just such an interesting and new thing in my life that I didn't have to experience before. Before, the only people I had to worry about were like other attorneys because they're inherently biased towards their other client, right? But now I have to deal with dummies, not just dumb attorneys, but other dummies out there who will like sycophantically say something that's not true about me and like overtly untrue. Not like offensive or damaging to me. It's just like so stupidly wrong that it blows my mind. I'm like, no, that's not me at all. Why don't you come check? Just come check. If you watch my show and then you hate it, great, fine. I don't care. So anyway, sorry about that. Next, Trump admin can't limit asylum protections for domestic and gang violence victims, judge rules. A federal judge on Wednesday blocked the Trump administration's policy that makes it difficult for victims fleeing domestic and gang violence to qualify for asylum in the United States and ruled that some people deported under the policy have to be returned. In a rebuke of the policy established by former Attorney General Jeff Sessions, peace be upon him, good riddance, Jeff, legal weed now, by the way, Judge Emmett Sullivan agreed with a group of women and children who argued the policy unlawfully imposed a heightened standard in reviewing their claims, concluding that the administration must stop deporting immigrants currently in the U.S., quote, without first providing credible fear determinations consistent with the immigration laws. So the long and short of what's been going on is that Sessions, presumably at the order of Trump, changed the way the regulatory structure for how ICE deals with asylum requests. So when you apply for asylum, you enter a country, often illegally, or sometimes you enter legally, but maybe under false pretenses, which makes it illegal. But let's say you get a student visa because you have the ability to get a student visa. What you're really trying to do is flee an oppressive regime, like we'll say Cuba in the 1950s, where Cuba was prosecuting the gays. And not just prosecuting them, but jailing them, specifically. Let's say you're a student in Cuba in the 50s. What you would do at that time is you acquire a student visa. I don't know if this would work in Cuba because of the embargo, but hypothetically, you acquire a student visa, you come to the United States, but when you get a student visa, you have to go ahead and say that you intend to return back to your home country when your visa is expired. That's part of the student visa process. We don't allow people to get a student visa and come to the United States to stay, which is weird in my opinion, but that's a different subject. So we say they have to go home. Well, you say, okay, I plan on going home. And then let's say 6 months into it, because you're a gay person from Cuba and you fear what the Castro regime is going to do to you when they find out that you're gay, you say, okay, I'm going to stay and I'm going to apply for asylum and then I'll overstay my visa at that point in time. So these are but you apply for asylum once you have entered a country, either legally or illegally. And if you're fleeing from another country, this is how the migrants caused the migrant crisis in Europe. However, you look at that crisis as either a bunch of migrants have entered my country and we want them gone, or a bunch of migrants have entered my country. How do we deal with them? Whatever perspective, it's still a crisis. So when you're coming into the United States unlawfully or lawfully, and you are fleeing an oppressive regime, you then file for asylum. And as part of that, you have to lay out what's called a credible fear. And the credible fear is a credible fear of persecution based on some trait or characteristic. Often it's political dissidence, like you are opposed to the regime and the regime is violent against its opposition. Like maybe they give them polonium-210 or something. Right, Vladimir? No, just kidding. No, I'm not kidding. That seems to have happened. But, let's say you're a Jew living in an African country where a strict Muslim regime takes over. There's a regime change and you've got like Al-Shabaab taking over an African country that has a significant Jewish population. Well, the Jews in that country would want to leave because they're about to be oppressed by a group of people who want them to die, right? So that would be an example. If there was in Israel a radical regime change that not only suppressed Muslim beliefs like they kind of do now, but if they jailed practicing Muslims based on their beliefs, rather than just said you can't practice in public, they said you're going to jail or you're being executed, like some hyper right-wing group takes over Israel, that would be, then those Muslims could flee to surrounding countries or to the United States and seek asylum. Okay, so that's how asylum works. A lot of people mix asylum up with refugees. Asylees are not refugees. They're completely different. The process for asylum and refugee status is different. Refugees go to a camp, and in that camp, they spend 2 to 3 years there. And what they do during those 2 to 3 years in some sort of camp is then they get assigned to a country, usually not of their choosing, or a country that they have a significant close relative presence, and then they're placed intentionally through agreement of the foreign government. They say, we're going to accept refugees as a group. Asylum is case by case and individually based. You make it after you've entered a country. Refugee status is typically applied to you before you enter a country, and then you get moved into the place you're going to go. So there's conflation about what refugee and asylee is because they're kind of changed. They're interchanged in popular media, and so people don't always know. So I hate to like sit and explain some of this stuff, but that's how immigration in this sort of forced immigration perspective works, and not everyone knows that. So I wanted to say that that's how that works. So just in case you guys didn't know. So what they're saying is that when you apply for asylum status, you have to raise a credible fear of this persecution. So you have to literally write down on a form that's reviewed in person by an ICE agent, and not a nice agent, an ICE agent, and you lay out why you're afraid for your life. That gets a review. Usually there's an interview, a face-to-face interview with an ICE agent. If you're applying for asylum in the U.S., bring cash, hire an immigration attorney. Let me just say that, okay? But yeah, you get an ICE agent. They review your claim. They talk to you about it. They try and determine if it's legitimate. They try and determine if you're lying. They check the conditions in that country. They'll check with the embassy in the country and find out if those statuses are correct, or they'll coordinate with foreign powers who may have an embassy if we don't. They'll do all of that stuff to have this threat assessment. Now, I'm not familiar with the exact rules, but it sounds like the policy that they implemented made an expedited process for people coming here who are alleging domestic or gang violence. I'm fleeing a cartel. I'm not fleeing the Mexican government. That's a different sort of standard. And the credible fear doctrine of immigration law traditionally has been applied to government actors. However, to provide the argument for the judge here would be to say that cartels and their ability to compromise governments and their ability to comprehensively terrify and enforce a set of laws, informal laws, through violence on people might make them, even though they're not a government operator, might put them in the same sort of category as that. So that's kind of what the courts would be seeking to determine, is if we do grant them excess or that sort of protection for a non-government entity, and in some cases, a non-traceable entity. Now, the Trump administration, likely in a big part of their, their policy has been immigration-based, specifically illegal immigration from Mexico, which does have a cartel present base form. And Sessions' comments on this have been basically that most of the asylum claims are actually bogus. People are using the fact that there are cartels and that there is violence to then make a claim that they get to stay. Whether you agree with that or not, these are both valid perspectives, and they're reasonable perspectives for the administration to take, and they're hard to kind of blanket categorize because every single asylum case is done case by case. Now, the converse of that is that these rules sort of give a guideline that might reduce that case-by-case analysis and therefore compromise what we would consider the asylum process. Wherever you fall on that issue doesn't really matter. I know a lot of people are anti-immigration and are very skeptical. Not immigration, but anti-illegal immigration. And asylees are typically illegal immigrants, or they hold over on a visa unlawfully. So I'm not trying to sugarcoat that. So a lot of people are anti-illegal immigration, and as a result of that are skeptical of the motives of these asylees, especially when it's like a 5,000 person horde marching across 1,000 miles to come to the United States, right? We should be maybe critical of those intentions. Why are they coming here? So these are all valid questions. The real question is who has the power in the situation. So in a rebuke to the policy established by former AG Jeff Sessions, Judge Emmett Sullivan agreed with a group of women and children, aw, that's cute, right? Who argued the policy unlawfully imposed a heightened standard in reviewing their claims, concluding that the administration must stop deporting migrants currently in the U.S., quote, without first providing credible fear determinations consistent with the immigration laws. Quote, it is the will of Congress, not the whims of the executive, that determines the standard for expedited removal. I'm not sure that that's actually true, because the executive has the duty of national security and is the sole organ of foreign relations. So that may not be a correct assessment by this judge. Congress has plenary authority to create a system of naturalization. So now we have a conflict between current immigration policy and naturalization, which is where this conflict comes from in the Constitution. If you didn't know, even when drinking, you get education on this channel if you're not aware of this stuff. So what we have is a conflict of plenary authority. The president is the sole organ of foreign relations. If you're accepting foreign migrants, either legally or illegally from a country, that part of that comes from the president's sole organ as a foreign relation or of foreign relations. His relationship with another state authority. Part of that is there. The other part of that is immigration part of the system of naturalization that is enumerated in Article 1, Section 3, or whatever, 6? Section 6? Maybe it's Section 6 of the Constitution, where they have, Congress has the authority to establish a system of naturalization. Does immigration policy follow from that system of naturalization? I actually would argue no. I think the executive has way more power in regards to immigration because the executive traditionally has been the sole determinant of who has access to the country. Prior to our system of government, you tended to need some sort of writ authorized by the monarch of whatever country or territory you were entering. Or maybe you'd get a writ of a duke or an earl or someone who is a prominent landowner or magistrate, but they were appointed by the monarch. They were under the executive power of monarchs. At the time this was written, the Constitution was written, that executive authority would be understood in that way. Congress has wielded it. Congress created the Immigration and Naturalization Act, which, as far as permanent immigration and naturalization to citizenship is concerned, is in their authority. But with that, they've roped in the visa process and all of these sort of other things that may not be a congressional authority. It may be an executive authority. And we've just held on to it in this way for so long. So it's a very interesting conflict of power when Congress comes against the executive on matters of non-permanent immigration. Because who has the power? I don't think anyone actually knows this. DFW Knight says, when they refer to fleeing domestic violence, they are talking about murderous families or murderous governments. They're talking about murderous families, and it's probably in the context of cartel relationships, is what I'm guessing that the claim is. But it may be just women and children escaping abusive husbands. And if that's the case, because, you know, we're talking about the women and the children, and if you ever want anything to be automatically good and noble and virtuous, it's always got to be for the women and the children, right? But we're talking about women and children fleeing, so they may literally be talking about domestic violence in the way that we understand it in the context of a family relationship. Okay. So then Landon Mackinjames says, what if the gays took over a country and Christians came here for an asylum or whatever, with these LGBT SJWs trying to take over anime? I could see it. That's political dissent and the oppression of political speech is an actual valid asylum claim. So that's a possibility. It's a long shot, but it's a possibility. But yeah, Marsupial, husbands fleeing abusive wives. Yes, equal time for the men. Actually, the only reason I mentioned specifically wives fleeing abusive husbands would be that we'll say that I hate to use phrases like this, but maybe more patriarchal third world countries, we would at least stereotype, whether it's true or not, we would at least stereotype them as being more male violent dominated. I don't know that that's true. I've seen some Mexican women wield sandals in hilarious ways against my friends and their dads. So if you've ever seen a Hispanic mom bust out the sandal, you know it's going down and you know someone is in trouble and going to be hurting, right? So maybe that's what's going on. But I think for the purposes of this article and the purposes of the public image, they're talking about women fleeing abusive husbands. So just to be clear on that, I'm not trying to like diminish the violence that women commit against men. It's actually a real problem. And at some point I'll have an MRA, a proper MRA on here to elaborate that position, because I'd like to talk about it. I'm not an expert on that subject at all. All right, back to this thing. Earlier this year, Sessions said that in order to qualify for asylum, and asylum again has traditionally been a power of the executive, not a power of Congress. So that's very, very weird. Sessions said that in order to qualify for asylum, victims must show that their home country was unable or unwilling to assist them and that, quote, the government condoned the private actions. The Attorney General has full authority over the immigration courts, a separate court system which operates under the Justice Department. And that's pretty true. The ruling is the latest legal setback against President Trump's efforts to limit asylum claims. Earlier this month, an appeals court upheld a ruling barring the administration from denying asylum to people crossing over the southern border between ports of entry. During a hearing on the credible fear issue in August, Sullivan erupted, well, that had to be sticky, at the Justice Department when it was revealed that two of the plaintiffs were literally on a plane to El Salvador while the hearing was going on. Sullivan ordered the two immediately return to the U.S. and threatened to hold Sessions and others in contempt. Why? They validly deported them, having them on a plane. Whatever. Lead attorney for the ACLU on this case, Jennifer Chang Newell, welcomed the ruling. Well, of course she did. She's the attorney looking for it, telling CNN, we think that this is an important setback to the Trump administration's all-out assault on asylum seekers. We will keep fighting against these wrong-headed policies. However, Sarah Pierce, a policy analyst at the nonprofit Migration Policy Institute, said Wednesday's ruling was unlikely to change the status quo, given its narrow scope focused solely on the initial stage of credible fear interviews. The vast majority of asylum seekers already passed the credible fear interview, a trend that has continued even after Sessions came out with the new standard in June, said Pierce, who is also an immigration attorney. Rather, it has been immigration judges themselves using the more stringent standard in their courtrooms that has affected asylum seekers the most. Those hearings are not covered by the judge's ruling, only that initial credible fear interview, she said, so not much will change. It's not as sweeping a ruling as it sounds. Now, guys, I would encourage you to take a day. Don't do this. I'm not actually encouraging you to do this. But take a day. Go to an immigration court. Immigration courts are specifically, they're different. There's a special court that you go to for immigration issues. They're not wrapped in with everything else. Everybody there will be there for an immigration issue. And many of them will be there for removal. Go to one of their open court hearing days. That's where people come in and they typically have an initial hearing for their deportation or they have a second hearing or something like that. Go watch that. And you will see like just how silly all of this system is. Because when you spend a day in immigration court, you listen to a judge literally just schedule out the next hearing 6, 8, 10 months later. Oh, I didn't get an attorney yet. You've had 30 days. I didn't get an attorney yet. I hired an attorney this morning, or I'm talking to an attorney. And they say, okay, come back in 6 months with your attorney. And then we'll talk about deporting you. And I mean, these are deportation cases. So like the idea is that these people are going to go and this is their last ditch effort to stay outside of an appeal. It's the first part of their last ditch effort. So this isn't the beginning of the process. This is already well into it. And then just watch as person after person is given 6, 7, 8, 10 months to stay. A lot of these people have held over past a 2 to 3 year visa. Maybe a 6-year visa if they got it renewed. And then they're being deported. And then they get another 6 months, 12 months to stay. And this is just procedural. Like that, it's 10 seconds. They walk up, say, okay, you got your service of deportation letters. Yes, I've been trying to hire an attorney and I just found one this morning. All right, come back in 6 months. It's crazy. The system takes forever and expediting it is not unreasonable. Like the idea, and I'm like many of you would probably hate my immigration view, and that's okay. I'm fine with that. But I'm close to being open borders. I want some controls over what happens when people are here, what benefits they have access to, what taxpayer services they have access to. But like people coming in and out, I have less problem with that than anyone in the Trump administration by far. So like this is me who kind of supports the idea that we could have a permeable border and make it work with some changes elsewhere. And I will tell you that the way we treat immigration court is an absolute joke. It's an absolute joke. And it's like this extendo, kick the can down the road thing. Okay. Indeed, data from USCIS, that's United States Customs and Immigration Services, shows the percentage of asylum applicants passing their credible fear interview has remained roughly stable each month throughout all of 2018. Has even gone up slightly. In January, about 76% passed the interview, the records show. In June, the month of the new standard went into effect, 74% passed. Meanwhile, by September, the most recent month available, 79% of asylum seekers passed the interview. The Justice Department on Wednesday, because that's just an initial thing. They say, is there enough information here to prevent us from sending someone to a place where they may die? Right? Like, let's say a trans person from Iran flees to America. All the asylum, all of the ICE agents' question is basically, did this person make enough of a case in their filing so that I don't send them back to be thrown off the roof of a building? That's it. I know that a judge and an immigration attorney that works for the state is going to look at this person, do a fact-intensive check. They're going to try and find out about their background. They're going to allow counter testimony and say, no, this guy's not in any danger. They're going to talk to the embassy at the other country. They're going to do all of this stuff, and the facts will come out later. Right now, if I send this person back, do they get thrown off a building? That's all this initial test. So of course, many people pass this test because you just have to lay out that you're from a country that has a history of violence against its citizenry and that you fit into one sort of category. They're going to ask later if you really do. You may have to go back eventually, but that initial question is pretty basic. So of course, most people pass this. Of course. You thought Iran was okay with trannies? Maybe they are. Okay. Justice Department on Wednesday immediately asked Sullivan to place the ruling on hold, pending appeal, except in relation to the specific individuals who brought the legal challenge. Quote, under the laws passed by Congress, asylum is only for those who have a legitimate fear of persecution on the basis of their race, nationality, religion, political opinion, or membership in a particular social group, said Department spokesman Stephen Stafford. Attorney General Sessions' ruling was about following that requirement. We are reviewing our options with regard to this ruling, and we will continue to restore the rule of law in our immigration system. Ultimately, if this goes to the Supreme Court, the administration may win on this. And that's the risk that I think is, like, oddly enough, what the lady was saying, the game journalist or the video game attorney was saying actually applies to immigration. They don't want this stuff litigated. They really don't want to put congressional power, which the INA, which is a weird, archaic sort of law from the 50s, which hasn't been significantly changed in a long time. The INA comes into conflict with presidential authority. The president very well may win on a bald constitutional argument about his authority to allow asylum seekers. Like, in this case, it may default to what Trump wants. If that's the case, say goodnight. Say goodnight. You want a group of people who don't want this litigated? Judge Sullivan puts this into a weird place because if they appeal it and win, Trump has a lot of power that people didn't know he had yesterday. And that becomes very, very terrifying for immigration attorneys and for asylum seekers. Imagine if Trump could shut down borders by his words without Congress involved at all. That may be a real possibility under the Constitution. And people on the other side of this should be really scared of that. So, well, guys. There was another case I was going to cover. What was it? It's Michael Flynn. Oh, there's a grand jury indictment that's kind of... so a grand jury did something, and then Mueller's team appealed that decision. So what I would suggest is that maybe a grand jury refused to issue an indictment against a foreign corporation. And then Mueller, his team has appealed that decision and apparently won the appeal. Although details are all sealed in this case, so it's really hard to say what's going on. But a lot of people are suggesting that this is also a blow to the Trump administration because it's part of the Russian collusion case. Even though they don't actually know if that's true, they're inferring that based on it being a Russian company and Mueller's team. Now, whether that company's actions implicate Trump in any way is not real. So what I would do is any reading you do on that subject, take it with a grain of salt, because never not take it without no grain of salt. No, take it with a grain of salt because there's just no details. They're all under seal, and no one really knows what that ruling is about or what it means yet. But it could potentially be just the overturning of a grand jury dismissal or something like that. When are you going to bring the bald guy and the ginger back on? I like them. Oh, so the the big brain panel. I love doing big brain panels. We'll do one as soon as possible. As soon as possible. I just got to set it up. And we'll have another Chad Dad chat soon as well with Doug TenNapel, Larry Blydner, and hopefully a special guest that will shock and awe all of you. That said, we're at about an hour and a half. No, 2.5 hours. I think I've covered most of what I want to cover. I will point out that behind that video, or behind that, of course, is Carlton's lawsuit. I have downloaded the documents for that. I think we may be going through that very soon. Because it's interesting to me. This is an interesting copyright thing, but I want to review it and at least consult someone who's better at copyright than I am on that case before I bring it to you guys in full. But I just wanted to let you know that I do have it. Of course, we are still watching the Meyer lawsuit. We're watching the Russell Greer lawsuit to see if he effectively serves some security guard at a Taylor Swift concert. Oh, what an idiot. We're watching several different suits. Hambly versus Loader. We're waiting to see if the quarter pounded gets the quarter pounder to stay in federal court, or if he agrees to bring him to Wisconsin court. There have been some interesting theories as to why he may have done that. Watching all of this stuff. So that's there. I am hoping that this Friday will be a stream with Cecil Says and Yellow Flash Guy. I don't know. Waiting for confirmation on that. If you remember, before I went on vacation, I had scheduled that stream, but I was stupid and take full responsibility that I had not considered that I would not be in my home that Friday night because we would be traveling in advance of going to the airport early in the morning. So I had to cancel that stream, which I really hated doing. But I am looking forward to having Cecil and Yellow Flash Guy on for a good stream, drinking, enjoying, having fun, making fun of people, hopefully using some naughty words or whatever makes people happy. And that I am hoping will be Friday, but I'm waiting for confirmation on that. Stay tuned. If you don't follow me on Twitter, follow me on Twitter to get updates about the weeks and the days videos as they come out. Tomorrow, of course, again, was the person opposed to Mindy Wheeler. So there's some comics content for you. Hopefully Wednesday of next week, we will have Russell Greer. And then Thursday of next week, we have booked, assuming nothing weird happens. In the meanwhile, we've booked Mark Kern, who is a producer of Diablo 2, a team lead for World of Warcraft, and is becoming more and more outspoken. I don't know if he's becoming. He is an outspoken tech industry insider. And we are going to talk about law, business. We're going to talk about platforms, deplatforming people. We're going to talk about the money cartel, as I've been calling it, the payment processing cartel. We're going to be talking about the tech industry in general, pushing left-leaning ideologies upon its customers and all of that. So that will be our discussion. We're going to stay away for the most part from Diablo, Blizzard, World of Warcraft, StarCraft talk. That's not why he's coming on the show. There will, of course, be a little bit of it. But primarily, we're going to focus on the legal and business and tech sides of things and how they impact the modern world. So that should be fun. I'm really looking forward to that. And I'm going to try not to fangirl on him for stuff like Diablo 2. Landon Mackinjames says, debate Dick on immigration and mealy booty. We'll see. We'll see. Here's the thing, guys. My immigration policy does not mean that I think other immigration policies are invalid or wrong. It's just how I think in an ideal world we could do things. We don't live in an ideal world, but I'm not the one making the decisions and the policies, so I don't have to deal with the ramifications. I advocate for ideals as ends to strive for, not necessarily as things to happen tomorrow. Things I'll advocate for happening tomorrow legal weed in all 50 states. Things I'll advocate for as principles, legal drugs in all 50 states, but not tomorrow. Things I'll advocate for tomorrow, legal prostitution in all 50 states. I'm not sure on that one. That's a good question. Because until we get a handle on other trafficking issues, is legalizing prostitution effective? I'm just not decided on that. But I'm trying to give you an idea that just because I hold a position doesn't mean that I think other positions are invalid or even ineffective or wrong. It's just not, it doesn't align with what I want things to be. Those are different things. So don't think that I'm attacking your perspective if it's different than mine. I'm just giving you mine. You can take it or leave it. Gojirify says, do a stream with Alan Dershowitz. Well, yeah, I mean, sure. Okay. I'd love to have Alan Dershowitz on. I'd love to have any, someone earlier mentioned someone kind of big. I don't know. But the question is always getting a hold of these people, getting their attention. So again, if you guys want me to see someone, if you've got a line to them, hook me up. Triangle, baby. Me, you, them. We both contact them. You give me a warm handoff. I will set up interviews with people all day. I like talking to anybody and everybody. Give me the worst Nazi you can find and give me the worst SJW you can find. I'll talk to any and all of them. I don't, I'll talk to people and find ways to relate to them and then find ways to disagree with them, hopefully in interesting and educated ways. So, help me get a hold of these people. I'll have them on the show. DFW Knight says, Scott Adams may sue Google for defamatory search results. What say you, counsel? Could he worm inside and start discovery based on that? Oh, that's going to be a real tough one. Real tough one. I don't know that he could do that. I'd have to look at the case. If he does, maybe we'd talk about it. PewDiePie. I'd love to have PewDiePie on the show, obviously. I'd love to have PewDiePie mention my show, of course, like self-serving interests. I would gain thousands of subscribers just by mere word from him. Of course, I would have PewDiePie on the show. The question is, I don't think he does shows for that reason, typically, but whatever. Again, if you've got a line to anybody, I would love to talk to them. But I'm not going to beg anyone to come on my show. I will invite them politely. I will ask them. I will treat any guest with courtesy and respect. So, Landon, Mag, and James, Weeb Stream, Nick, come on, lol. Yeah, buddy, we're going to do that. Maybe we can do that next week. Let me start. Remind me. And I think next week's Friday may be open, and that might be a good time for a Weeb Stream. Just remind me, Landon. Message me or whatever and keep me on top of it so I can help organize it. We just got to get everybody in place for it. So, get Taylor Swift. There you go. All right, guys. I think this is a good time to end for tonight. Thank you all for watching. I really appreciate it. I always appreciate the support. I'm bad at doing this, so let me try, because if Keck were here, he would tell me to do it. Lawsplaining on Patreon. Come check it out. If you find this show to be a value to you, and you want a little more interaction and you want to support me, you can support me at the $1 level. That won't buy you any extra interaction. That's just you saying, I like the show. Here's $1. I really appreciate it. $1 a month. I really appreciate that. It means the world to me when people do that. $5 a month, you get access to the Discord. Interact with me. Typically, I'm pretty good. If I'm on vacation, it's hard because I try to make Lady Rackets happy, and being on my phone all the time doesn't always make her happy. But I try to be responsive on Discord as much as possible. There are times that's plus and minus, but it is more interaction and it's more candid interaction than you get on here, in just because it's a different medium and we talk about different subjects. And then, of course, on Wednesdays, we do live chats every Wednesday, unless I'm on vacation, right? Every Wednesday, we do a live chat where I do a 2-hour discussion. And we talk about whatever subject anybody wants. Doesn't have to be legal. Very fun, very candid. At the $10 level, you get to participate in those discussions over voice. At the $5, you can listen in and do text or whatever. $10, you get voice. And then at the $20 level, there are different rewards. Sometimes when I do specific content that is not a live stream, you get a live stream of me recording the content. So that's kind of fun as well. Maybe, I don't know. And then I tend to listen to my $20 donors about stuff they want to do. And then sometimes we play video games together whenever I have time to. So that's it. Check out the Patreon. Follow me on Twitter. Like and subscribe. We're like less than... What are we at? What are we at? Where's me? We're like 600 subs. God dang it. Come on, YouTube. Don't do me wrong. We're like 600 subs from 15,000, I think. 603 subs from 15,000. And at 15,000, I will have my friend Drexel on the show for a 15,000 subscriber spectacular. And he's the large black man and the source of the infamous blackface picture where I dressed up as him in a picture that I literally never thought 15 years later, whatever it was, would have any impact on my life ever, because it was just a fun picture of me being my very good friend. But whatever. At 15,000 subscribers, we will have him on. Maybe we'll do a Battletoads stream or something like that. I'll buy a capture card and we can really make this thing a disaster. And we'll talk about fat women and all sorts of stuff like that. So thank you all. If you haven't watched that 10,000 subscriber episode, it got demonetized from YouTube because YouTube hates black people. I want to say that specifically. So it doesn't get promoted. So the view count on it is actually kind of low. If you haven't watched that stream, go watch it. It's great. It's great. He's a very interesting guy. And we'll have him on at 15,000. Anyways, thank you all. Love you guys. We'll talk to you tomorrow. Have a good night. Peace, I think. Yeah. Have a good night. Peace. All of that stuff. I was just checking a direct message and making sure it wasn't pertinent to the stream. So, thanks, guys. Talk to you tomorrow.